Thank you for having us, sir, knowing well how much every hour of your time cost. So you're a man who has done it all. From dazzling courtroom as a youngest senior designated advocate, and then serving as the youngest additional Solicitor General. You have, and then having a lucrative legal practice. I think you have done it all, and it's very difficult to fit it into one introduction of all what you have achieved. So I think it's better to just call it, you are a master of law, public speaking, and wit. I think that justifies.
It's very kind of you, Simran. It's nice to hear such nice words from you. I don't think I deserve all your compliments. And the youngest part, I'm no more young. And the cost part, let me tell you that probably 33% of all my work is pro bono.
Oh,
so
that's so nice.
But it's very nice of you to say all these things.
So you're being very modest. I just like to know, so you started as Manu Singhvi, but along the way became Abhishek Manu Singhvi. Was it just a name change, or could you call it your first life lesson as to how society and ideology intersect with each other?
There are stories attached, many stories to each of these events. My grandmother was reading the Manusmriti when my mother was pregnant. And therefore, as far as she was concerned, Manu was the greatest man. And she said that if it's a son, a boy, we must name him Manu. And her writ ran. So I was actually named Manu and only Manu. Number two, my family was, both my parents were very, very literary. Both were Sanskrit, Hindi scholars, my mother, and my father also an English scholar and a writer, and my mother's published 6 books in Hindi. So after some time as I grew up, they both felt that Manu tended to get distorted into Munna or other forms, and it was not sufficiently literary. Abhishek was a very less known word that time, except in Bengal it was used. But outside of Bengal, hardly anybody had the name Abhishek. And they chose that. So I think somewhere around 14 or 13 or 15, I was named Abhishek. But Manu was retained.
Okay.
So by a formal name change, it became Abhishek Manu Singhvi. Now the last is the interesting story about the Manu. When I finished my studies from Cambridge, Trinity College, I somehow got for a few months this crazy thought in my mind that the best area of law practice is excise law. So I asked my father, I said, where should I join? He said, the number one chap in excise law is Ravindra Narayan of the then reputed JBD firm. So a young idealistic chap, I landed up, and the first person I encountered in the Connaught Place office of then JBD on my first day was a lady sitting there. And I came and sat in the same waiting room, and I was trying to be nice with her, and I said, I'm so and so, etc. She just didn't smile, she looked at me. And I turned out later we became good friends, but she was Nandita Haksar, incidentally the daughter of P.N. Haksar, an activist and a well-known activist on many different areas. So after glaring at me for 5 full minutes, she says, so you are Manu Singhvi. You must change your name immediately. Manu was that tyrannical person who said a woman is always dependent on a man, in childhood on her father, in youth on her husband, in old age on her son. I will not talk to you unless you change your name. So these are nice stories of life, because I believe everybody should be judged contextually.
Right.
Manu in many ways was a great figure. His thoughts were contemporaneous and contextual. He also acknowledged as the lawgiver in the Indian ethos, Indian thought system. He's acknowledged as the a person who is supposed to be the equivalent of Noah also from Christianity. But equally, Manuvadi is a dirty name today. So these are all things you have to see in historical perspective and be reasonable about it.
So I think
I don't judge people like that.
So it could be said that it was changed or shaped because of feminism and generational change of generational views.
No, I think my name change was completely based on literary merit. Because
the
Abhishek
meaning later which was given to it.
Yes, well, I mean, as I said, times change, thought processes change. What were great treatises would have many sentences and passages
Right.
which might not comport with current thinking. But I don't think that's a fair way of judging anything.
That's fair. So you have grown up surrounded by literature, public life, poetry. How much has it shaped you as a person and lawyer both?
Unfortunately, only in interest terms, not in accomplishment terms. My father was a great scholar. He could compose Hindi poetry, he's published. He was a Sanskrit scholar. He complained to me in the 70s that, look, I have nobody to talk to in Sanskrit, converse in Sanskrit. So my Sanskrit is going bad. My mother was a authoress who published more than 6 or 7 books. But the culture in our house was full of 2 things in my growing up years. One was the constant stream of poets and writers and literatures who would come to our home. Ramdari Singh Dinkar, I remember hearing his very powerful voice on our lawns, reciting the Veer Ras poetry. Mahadevi Verma, my father's best friend Prakash Veer Shastri, who spoke in a loud voice, a Hindi proponent, and many, many more. I'm not taking the names. Kavi Sammelans were held in our house regularly. My father later became the chairman of the National School of Drama, NSD. So I have seen some of the best players. Fortunately, no videos, no mobile phones, no internet.
Immersed in the
Our
moment.
basic outings were picnics in Lodi Gardens and Buddha Jayanti Park, or plays, or at home because of my father's large repertoire of friends, Kavi Sammelans. But those were fantastic times. Mahabhoj and Mukhyamantri are 2 plays, I think the likes of which I've never seen earlier. And all these people, many of them used to come to our house, Om Shivpuri, Bajaj, even the other present Bollywood actors and all. So that was a different era. Life was different. And I cherish that. I love those things, but unfortunately, I'm not as accomplished as my parents were. I speak good Hindi, I can write good Hindi, but I wouldn't call it a literary one of the kind I would like to.
Could I say that before law claimed you, theatre did? Because I think you did theatre as well. Briefly.
No, I think that's not a fair comment. I have done a lot of things, but I don't think it can be said that I had any resonance in theatre. It started like this, that because of my interest in National School of Drama, I always tried to dabble. And we were living in a house opposite the India International Centre, which was my second home. A very accomplished and a talented person, the son of the great Al-Qazi, Faisal Al-Qazi, also was into theatre. And he started an IIC theatre club, of which I was a nascent member. So I did my one and only play on IIC, A Slow Tomorrow, where I played the role of Halim. But I soon realized that is not my core competence. Just like trying to learn the piano, etc., was also not my core competence, though I dabbled in all of this in my early years.
But I think law, because you went to law, and I think law is an intersection with various, a lawyer cannot be said someone who just confined to law. So all these aspects of life, one way or the other, they have contributed to.
Oh, absolutely. I entirely always believe that no part of your life, no part of what might be seen as an eccentric or a deviant activity is ever a waste. It adds to your knowledge, it adds to your personality, it adds to your growth as a human being. I'm married to a very accomplished singer, but I've always loved Bollywood music on my own. So nowadays I indulge myself in actually singing, although privately and in a low-key way. When I was doing a PhD in law, everybody except my mother kind of discouraged me because a PhD in law is wholly unnecessary. Very few people do it and it's considered a waste of time. And even my father, who's himself a PhD in law, started saying after some time that, look, why are you wasting your time? Why don't you get into practice? But I realized after joining practice, it's not a most wasted moment. There was a deeming fiction of erudition and knowledge in me because I had a PhD. There was an acceptability and a resonance which I had not expected when I was doing a PhD. So the point I'm making is follow your interests and do not think that what might seem contemporaneously as a waste of time is actually a waste of time. It adds to your experience, to your thinking, to your to your career even, in ways unknown and mysterious and strange.
That's really profound what you said. Uh, so now we go back to law. You are known someone who can turn complex briefcase into bullet points. And majority of the time, I think all of us, all lawyers, one time have gotten bashing from their seniors saying you've not read your files properly or you don't know how to read your files. What would you suggest? What is the way to read files, not just thoroughly, but intelligently?
The first is to remember that law, as in many other professions, is 99% perspiration and 1% inspiration. As they say, there are substitutes for Harvard. There is no substitute for hard work. Number two, remember that when you stand trembling in your shoes before a judge or in court on your first, second, fifth, 10th case, your best friend is not your parents, is not your fiancé or husband, is not your party-going friends the previous night. It's the amount of work you put in the previous night on that brief. That's your best friend.
Right.
Being a very young senior advocate and additional solicitor general, I faced on a daily basis a Venugopal or a Nariman or a Soli. And I realized that on standing up to them, the best friend is only this. Third, I think, and this happens over experience, doesn't happen by a push button on the first day. The heart of reading a file is to separate the wheat from the chaff. So very long seeming files have only got 10 or 20 relevant facts.
Right.
So you need to, by practice, as you do more and more, you kind of realize how those are the relevant facts. And then to build your case on them. And always to build your case first on the facts. Because law and jurisprudence is based first and foremost on facts. Law comes later. And fourthly, I think speed reading is a self-preservatory art, which if you can develop is a good idea. So I don't think you should make much of it. You have to just kind of put your nose down to the grindstone and start being methodical. And I'm happy you mentioned the points because I call myself the inventor of pointillism. See, it's easy to make fun of it, but it's difficult to be pointed because pointed means precision and precision means brevity. And brevity is always very difficult to achieve. So you force yourself to identify in the descending order of importance what you think the judge will appreciate most, second most and third most. And then that becomes pointillism. It also prevents a lot of waffling and rhetoric. And in today's troubled times of lack of time and overcrowding and overburdening of numbers, I think people appreciate if you are able to pointedly put your case.
That's you're known for keeping your arguments crisp, on the point. Otherwise, it's, a lot of people, those who like to indulge in theatrics. And considering how you mentioned the time, the lack of time, I think it's very important to, and the points you have mentioned, I'm certainly sure that it's of great help to all of us. But at the same time, you are handling so many matters back to back. How do you keep it so straight, like each case after each?
See, a lot of it is because of, just getting used to it and having experience. So I think length of time does help. Repetitive practice makes a lot of difference. Secondly, I think you need to always realize that do what you can well and don't regret what you missed. Because you do end up missing so many things. I have a lot of tension. I have more tension about the contents, about reaching a case and about managing all my diverse cases than about the content of each case. But you can't allow that tension to get to you. And you have to ultimately say, look, I tried my best. I tried for a Passover there. I tried for a rushing there. If I didn't make it, I didn't make it. It's not my fault. So, getting over hyped about it is detrimental, not only for the case you're doing, but for your health as well. I have been fortunate in that multitasking has been the joy of my life. It's also been the bane of my life. Being in large practice, all days in court are tension-filled. My juniors have learnt now that I am very short-tempered and very, very quick and a little merciless on them. But they know that I don't keep anything in the heart. And then they know that they only learn from my shoutings. And I believe that for a junior to learn how to keep the case alive for a senior with passover or starting the matter temporarily till his senior reaches is as much an important training as the content and the merits of the matter. So, because he is in an ecosystem.
Right.
It is not the abstract thing of reading a statute or the case file. You are in the ecosystem of litigation, where it's very different from corporate lawyering or in-house lawyering or advisory lawyering or even solicitor lawyering. In litigation, you need to learn the ecosystem, and part of that ecosystem is the chaos, the running around, the passovers, the managing to reach, the managing to ensure that you are able to reach.
This is what experienced Dr. Abhishek Manu Singhvi is saying. But if we go back to young Abhishek, Dr. Abhishek Manu Singhvi, first time in court, more nervous or more certain as to what he's expecting?
Oh, terribly nervous. I mean, not nervous. Nervous is a mild word.
No.
And I think there's nothing to be ashamed about because, as they say, nervous means adrenaline. And adrenaline frequently makes you perform better.
Right.
It's not good to have a flow of adrenaline 24/7 right through your life. But on the occasions it does. If it's taken in a positive spirit, it improves performance. I, in particular, am a perfectionist by nature. And your first few faltering steps in court, are always very self-critical as far as I'm concerned, because I, in retrospect, do a rewind and say, look, I did this wrong and I did that wrong. And by the time you are done, you think that everything you've done is wrong.
Yeah.
That's good and bad, because it makes you introspect, it makes you improve, but it's also very negative thinking. I'm also I don't treat it as a compliment, I treat it as a vice. I'm over self-critical, which is not good. So you must have, I think, a greater degree of confidence. I, on the other hand, look always for the negatives first about my own case. So that's the way of thinking. It helps sometimes, it doesn't help sometimes. But in my first few years or first few cases, I ultimately soon realized that the best thing is to be able to be confident about your own knowledge. Because the judge is handling 50, 60 cases. You at that stage of your life are handling maybe 1 or 2. So why can't you be a master of your brief and not worry about the judge who, despite his hostility, despite his questioning, you must realize knows much, much, much lesser than you do.
I think if you know your facts on your tips, half of the battle is won there.
I entirely agree. Most people make a mistake of thinking because they see these big sounding case laws and judgments, and rightly so they get enamored and they get lost in the maze of jurisprudence. Jurisprudence is important, but it's far more important to know how to search, pluck out, and then apply a relevant jurisprudence. You know, today, in those days, we didn't have computer. We used to search the ad manuals. But by press of a button, you can get 1,000 cases. It's useless. You need to first see your facts. You need to prioritize your facts in descending order of importance. You need to separate the chaff from the wheat by prioritizing only 10, 20 relevant facts out of maybe 100. Get your dates organized, then apply them to your arguments in nuanced manner. This will come first, this will be my second argument, this will be my third argument. And then, once you've done that, you can say that, look, the most important of my 6 arguments are these 2. Let's see if I can get bang on point that principle of law. And then, by reverse engineering, you get that judgment. Rather than be enamored of 20 principles of law which you're trying to fit into your case.
Right.
Your facts come first, your fitting in has to be with the law.
I think this has become the master class for litigating lawyers. Like you are revealing all the secrets of great lawyers. Do you remember the first time judge had really cut you down to the size? I think
Yes. I remember it was a very bad experience, and I will not name the judges. They were good friends later. But in the Delhi High Court, before a bench, in my very first few days, I was rebuked. And I was rebuked partly for something I was always fearful about. Namely, I was not such a master of procedure. So procedure always terrified me.
Okay.
I had become pretty good by reading up the brief and by knowing the law and by applying the substantive part. But procedure terrified me. And I don't know what it was, but some mess up in procedure. And the judges rebuked me, also because I was literally in my first week or first 10 days. And I remember how I was smarting and my ears got red. And I kept smarting till I went out. Madan Lokur, who later on became Justice Madan Lokur, who, by the way, was a standing counsel with me when I was the ASG for Delhi High Court. Extremely fine man. And later on, he succeeded me as ASG from being standing counsel. Did some hand-holding and kind of consoled me. But, you have to learn not to take it to heart. Because judges also tend to say it in the heat of the moment and then they forget about it. But I think judges, if they know that the chap is newish, should be a little gentle. That's all I feel. I mean, otherwise it's good to go by the test of fire and good to know that you are wrong. But it helps to not to demoralize you or not to destroy your confidence.
But it instills fear also in some of the young lawyers or fresh law graduates, because you are not taught this part of the law in the law school. Like, you have read the law, but the art of courtroom, that's you experience when you step into the court.
Absolutely.
So what advice or suggestion would you give for the young lawyers? Like,
well,
not to
I
take
don't
this to
want to
their
sound
heart.
didactic or Updeshwadi, but I think long term, if you follow a few things, it helps. One is, don't appear to be brash and Mr. Know-all or Mrs. Know-all or Miss Know-all. 2, have humility. 3, the humility must be backed by solid supreme confidence, which in turn 4 comes only with knowing your brief inside out. That gives you a solidity and confidence which nothing can equal. 5, never ever take liberties with the facts and the truth. See, what happens is, you appear in this court, say I am the court of 20 judges. You are appearing before me for 20 years.
Right.
So your reputation is built piece by piece, brick by brick each day. It's never built in a moment. I can excuse a slip of your tongue once, but if I find you misstating facts, taking a shortcut and being over clever and suppressing or misstating or misrepresenting or exaggerating, then I will cease to trust you. Not because you may be right in the next case, but I have formed my view about you in this case. Judges frequently go on trust. Many lawyers who say this, they will never cross-check because they know it's correct. If I have to cross-check you on everything, that's not good for your long-term development as a lawyer. So I think being straight helps. Then also coming to the point and sticking to the point. But there, not being weak or scared of, you have to be firm. You have a point. There are judges who will try to override you. There are judges who will try to maybe, dominate you. And judges are human beings, they are wrong also.
Right.
So you have to stand your ground. Also, you need to have a speed which is slow and steady, so you can know how to say the same thing in 5 different ways. Because the judge will reject you first time. The art of advocacy is to tell him the same thing in a different way. As somebody put it, the diplomat's art is to tell you to go to hell in a way in which you start looking forward to the journey.
Right.
So you need to really repackage the point and put it in different ways so the judge doesn't realize that he is going to be accepting what you are saying, having rejected a variant of that just 5 minutes ago. For all this, you require a certain confidence in yourself in terms of the brief. That is the number 1 point. And lastly, I think judges also, they must be very firm and critical. I am one of those because I believe that firm criticism helps you. But they must not be flippant or humiliating. They must not be casually making remarks, because that poor lawyer, you in front of me, doesn't have a right of repartee. And I have to be sensitive enough to realize, I think this is, lawyers and judges are part of the same ecosystem. So they must make their point clearly. They must be even negative and even harsh, I don't care. But they can say the same thing, the same harshness with dignity.
That's
Because otherwise I'm destroying your confidence and self-confidence. That will have a lasting mark on your career, and that should not happen.
And now, even considering how everything is amplified on social media, Now, because there is life proceedings going on, social media access to it, so every action taken by a lawyer or even for a judge, do you think now we need to act in a more restrained manner?
Of course.
And
I have done 75% of my practice in an era when there was none of this. Obviously, the rules of the game have changed for everyone. For lawyers and judges, of course, but for litigants, for court clerks, for everyone. One, you must remember the power of exaggeration, what you call amplification. So always be aware of it.
Right.
Automatically you will, counter correct and course correct. Second, be aware of the fact that it is selective. So understand that when you say a sentence, how just the last 3 words of the sentence plucked out selectively can completely distort the meaning of a sentence.
Right.
So say a sentence in a way that I cannot pluck out selectively and distort the meaning. Because the great art of social media is to distort the meaning by selectively plucking out a fractional part of what you said. And standalone, it sounds very different from what you meant. Third, I think social media can be very superficial and very transitional. So always in the reverse order, counter check your facts before you rely on social media.
It's true.
And fourth, even more, this whole thing of AI, I believe it's a great tool. I use it myself. It's a great slave, but always use it like a slave. Do not move ahead on it without counter checking, cross checking. The other day I was giving a speech, I wanted to check up some facts. I did it through ChatGPT. It's a great help. It's a great slave. That's what it's meant to be. But then I immediately thought that, look, I knew those facts were correct, what was answer to be. But I still got it checked up because I don't trust you entirely. And that's the way it should be. So these are things which you must learn. A lot of people are taking shortcuts now as juniors. That shortcut should not mean that you leave your power of rationality.
Like you mentioned about AI, so if given, what is that one in law or governance which you would want that AI should take over? Like one thing where AI would be really good at,
No, I am.
and another,
Yeah,
sorry,
go on.
and another thing where you think that AI should not have control at all, it should always be the humans.
There are no absolutes. I think these areas go into shades and then merge ultimately. But for most things, I would say, almost all things I would say, including the extreme example of a robo-judge sitting next to a human judge. Ultimately, in gradual phases, not now, it has to be a gradualism to it. You know, we didn't achieve internet perfection in Google within 2 years or 1 year. It took 10 years to stabilize. Right. Same way, ultimately I would say there should be no no-go area for AI. Subject to condition number 1, it has to be kept as a slave. Condition number 2, you have to dominate it, not vice versa. Condition 3, even in the extreme cases, it is only a speed assister and a provider, not the final voice. So for example, there are already simulations that you will be maybe in 5 years, maybe in 10 years, sitting across a room where a robo-judge is hearing. After you finish, and there's a real human judge in the back room. Towards the end of he also hearing you. Towards the end, he will come and sit with the robo-judge. Now the advantage of this is that the robo-judge will give you he'll give the human judge 3 alternative judgments, which are the best in the circumstances. But thereafter, the judge has to be intelligent enough to only use the material and come to his own conclusion. Now, I don't see any harm in that so long as the rider of the horse is a dexterous rider. It's an unruly horse. Right. So if you give a foolish rider, which translates into a not so good judge, then it's your problem. It's not the AI's problem. These things require skillful handling, but they are very useful tools.
So even I have read somewhere that I think it's an American Bar Association. What they have done is they have gotten an AI arbitrator for the construction law. For example, they have fed at least 15. I'm not sure on numbers, but let's just say they have fed 1,500 awards of the similar matter, so that it could present the award on those particular cases only, of 1,500 awards which has already been fed to it. But like you said, I am not sure if they have a human arbitrator there to actually, the intention is to replace human arbitrator with the AI
There I will
altogether.
not agree.
And that,
You see, there a lot of areas you can have replacement. Repetitive, by rote, uniform, similar or identical activities you can have. For example, registry work, batching matters.
right.
Various examples I can give. I wouldn't object provided the software is of a advanced kind. However, ultimate judging I would not. That's why I've always given example, even the extreme example, the robo judge must have a final word with the human judge. Now, the sample selection of the data which the robo judge has necessarily will be finite. Necessarily doesn't have the intuitive grasp which a human judge can have.
Right.
You see, you can go to the last mile, but the last end for a criminal matter, there is an intuitive approach by which I convict you or acquit you.
True.
So that ultimately, these are good for providing the human judge with the templates, with the materials, with judgments, with jurisprudence, with reasoning. But then he has to bounce it off him.
It cannot
So
be
it
a
requires,
replacement.
absolutely, I'm very clear about it.
Which was, I mentioned arbitration. You are one of the, like, you were present there when how the modern arbitration has unfolded with the Renu saga. How is it today, and how much it has gone in the way you viewed it at that time?
Well, I had the privilege of appearing in almost all the important cases of the, not the arbitration, but the litigation on arbitration, which emanated from the Delhi High Court and the Supreme Court. And Renu Sagar, of course, the most famous one. I did 2 rounds of it, which means 6 rounds. Twice it went to the Supreme Court, so 6 rounds from Bombay, etc. But a lot of other cases, Tresser and this, that. And these are all well before the new act. And after the new act, of course, we've done another set of cases. I unfortunately have got disillusioned with this branch of law. The law setting is very good. I like the fact that I've set the law in the judgments which I've won or lost, but the law has been settled. That's the law on arbitration. But what I feel very dejected, disappointed about is the arbitral process. That I am not at all enamored of. According to me, the way for the future is mediation. Arbitration, unfortunately, has become a pre-litigation litigation. It is adding, you have a litigation of level 1, level 2, level 3, level 4, takes you 20 years. You add one pre-litigation level, which is arbitration. That is never what is intended to be. Now we have this brand new act, but there are enough problems with it because it's adjudicatory. It imposes a result on you, which is not liked by me. So it goes into other levels. That's the big plus point of mediation. It doesn't impose a settlement.
Right.
So I think you cannot do away with it. For complex matters, it is going to be there. But the arbitral process requires a lot of overhauling. The law I am very happy with, that slowly the creases are being wrinkled, the wrinkles are being, and the creases are being ironed out, and the solutions are coming. And there I have helped in appearing in matters and settling the law.
Even the Honorable Supreme Court has said that arbitration is creating litigation at every stage.
That's what I said, pre-litigation litigation.
So what is, like, if you could suggest some changes, what changes you think that are required in this area of law?
Consistency of approach is the first. I mean, any number of cases. You see, you take Balco. There was Balco 1 and there was Balco 2, so to say. Between Balco 1 and Balco 2, the progeny of Balco 1 meant hundreds or tens of matters across high courts followed Balco 1. Then you change the law, so all those went by the side.
Right.
Now, how a judge looks at arbitration in a trained manner, modern arbitration in Delhi and in Bombay, and that's what you tend to think of as arbitration, is totally different from how a civil judge looks at the primary arbitration matter, because in other places it doesn't come to the High Court.
Right.
In Himachal or in Kerala or elsewhere, the way he looks at an award in a section 34 and the way you look at it in Delhi are very different. So what happens is that ultimately it becomes an appeal. It's hedged in with all kinds of limitations. It's not supposed to be an appeal, but ultimately it becomes an appeal. So I think today, in a nutshell, the higher courts have broadly got the approach of 34 and 37 right. But then in the lower courts, there are inconsistencies, always. Inconsistency is a big problem. Secondly, I think the the Act needs redrafting for simplicity. One of the most horribly drafted sections is 34. Let me be very candid. Point, exception, exception to exception, explanation, proviso. This is not the way a section is to be drafted. It's a happy hunting ground and a paradise for lawyers. It's a nightmare for litigants and a bigger nightmare for judges. So you need to get all your act together. But ultimately, you have to somehow strike a balance between reviewability, which must be minimal, but equally the quality of. Sometimes review is done because the quality of the award is so poor. So even though it may not technically satisfy the requirements of 34, the judge's conscience is shocked. So it's a comprehensive, multiple way street. The quality of the arbitral process must be pure. The quality of arbitrators must be outstanding. You'll automatically start having less interferences. From the other angle, judges must be restrained in not interfering. Now today what is happening is that from both angles there is a problem. Sometimes the award is so obscenely wrong that even though you don't satisfy a 34 condition, my conscience is shocked, so I must jump into it. In the reverse direction, judges sometimes are very casual and treat 34 as an appeal.
Right.
So it's a matter of introspection on all sides. Appoint good arbitrators, get trained arbitrators.
But majority of the arbitrators, at least in high-stake matters, turned out to be retired judges only.
So there is a lot of variation in quality.
Yeah.
There is no doubt in my mind that there are good arbitrators from retired judges, a few outstanding, and many not at all good.
That's true.
The integrity of the process has a question mark. Let's be blunt about it.
And since the confidentiality of the nature is the confidentiality, you don't know how it operates. And that's
Confidentiality is one part, but the problem starts from, various appointment, from personal affiliations, downright corruption is another one.
okay. So now moving back to the very common, like I was having a conversation with one of the student from a law school, and what they feel is unless and until you're born into for you to have a legal greatness, you have to born into one. What's your take on it?
Let me not discourage but exterminate all such thinking. Not only are they wrong, they must not think like that. They are wrong factually. It may have been true at one time. No. Certainly it was much truer when I entered the profession. I always like to say that the three biggest changes in the legal profession from since when I entered to today are the following. One, people with no legacy in law are entering law.
That's true.
Children of doctors, engineers, consultants, or architects want to become lawyers. I had a very funny incident where I'll not go into details, but very funny incident where a top industrialist, I mean, genuinely one of the top 5-7 of India, asked for time to see me and said he's getting his son. As soon as he entered my room, he said, Abhishek ji, I have got this chap for you not to mentor him or tell him how to do law, but to tell him why not to do law. Because this crazy chap wants to do law. Who look after my industry? So that's the first point. People are now finding law to be a matter of great interest without any legacy. Number two, there is from law being a refuge of last resort. Simran tries 5 exams, fails. Singhvi tries 2 exams, fails. Then goes into law practice. It has become from refuge of last resort to option of first choice. You change. Don't take it for granted. Third, women, ladies are doing better in this than ever before. In quantitative terms, when I entered the profession, there were very few. There is an explosion now. But forget quantity. At every level except the very top. The very top I would not say because it takes time to reach there. But barring the very top, at all levels, the high, the very high, the middle, the lower, all levels are doing well. And today, the democratization of law is the reason why law is certainly not for the elites within law families. Today, people with no connection are doing, and they're doing well. in corporate lawyering, in in-house lawyering, in solicitors, any number of people you meet. And that's a very positive sign, very good sign. So that thought process is wrong.
But unfortunately, it's the you open your LinkedIn and there will be multiple posts where some first generation lawyer is grieving about the fact that he's first generation and has to go through A, B,
That
C,
is a
D.
perception, that is a psychology. I appreciate that psychology because around you are many second and third generation people. But that has, no doubt it is there, I'm not saying it's gone. But the effect of that in the profession, in hiring, in promotion, in doing well, in being heard by judges, is probably 1/10 of what it was when I came in. That's the point I'm making. I'm not saying it's not there at all, but maybe 1/8 or 1/10, which is a far greater improvement now.
It's true. If we look back at your journey, what is that one unexpected experience which you still think of very fondly or funnily? Like in court, in client meeting, or anywhere it must have happened.
You're asking legally in law practice. It's a very difficult question because I must have done thousands of cases and it would
Something which is
certainly
stuck with
very
you.
landmark or funny, many would qualify. So it's difficult to pluck out. It's like choosing between children. But if you were to force me to pluck out a significant moment, was when I argued. My father and I started NTPC Singh, another major arbitration case, in court number 24, just before then Justice Wadhwa.
Okay.
We lost. Thereafter, my father lost interest in the case. For some strange reason, NTPC persisted with me. By the way, a digression. This is where unknown factors in life help you. I was a PhD and the retired Chief Justice advising NTPC in that case, Chief Justice of Delhi High Court, was Deshpande,
Okay.
who was academic minded and had a doctorate also. So he somehow liked the fact that here is me, young chap, and he said, go with him to the DB, having lost. It's a very big case. So I was very happy. I said, look, please take a senior. I was not a senior then. But they persisted with me. I argued the matter. That gave me a big break before a division bench, a powerful division bench of Justice B.N. Kripal, who heard it patiently, but again held against me. The turning point came in the Supreme Court. On my insistence, they engaged a senior, not my father, Shanti Bhushan.
Okay.
And a strong bench of Justice Tommen heard us. And since I was constantly assisting Shanti Bhushan, in the rejoinder, Tommen said, we'll hear Dr. Singhvi. I was not a senior there. And it was good of Shanti Bhushan also to agree. He said, of course, he wants to hear you, please argue. So I did the rejoinder. And lo and behold, after two concurrent reversals, adverse orders against us, NTPC Singer, as reported by the Supreme Court, reversed the other two, and we succeeded. So these are kind of breaks which happen by various, funny and very various coincidental events.
If you are a legal stalwart and there are others around you, what is that one common quality which you find in yourself and your peers that's like, which...
Undoubtedly hard work.
That's...
There is, as I said, it's 1% inspiration. It's 99% perspiration. I don't think anybody, if you call the so-called ones who have arrived or done well, I can't think of anybody who done it without solid hard work. In a lighter vein, the one person who managed it and his motto, proclaimed motto was minimum work, maximum output, was C.K. Daftari. Those were slower times, easier times,
Right.
not so frantic and crowded times. But otherwise, everybody I know of would have been working very hard, although it might seem easy in the front or on the top. So I think I would say that for all persons. And of course, you need to enjoy what you're doing. You need to love what you're doing. I forgot to say that.
Yeah.
You may work all the hard work, but if you hate what you're doing, you're not going to get anywhere. So please change the profession if you hate what you're doing. But if you start, and obviously I don't say stop it by hating it 1 day, 2 days. If you spend 1 or 2 years and you consistently hate it, then this is not going to get you anywhere. You need to love what you're doing and like what you're doing and enjoy what you're doing. That gets to you after a while.
That's true. And what is that one human mistake you see very most commonly made in courtrooms, which makes you a little smile also, like making that mistake, common one?
Well, a common one is to not be able to go with the judge or read the judge and move in his same pace and same direction. So you are very full of the case. You know the case better than anybody, including the client. But you are rigid in your thinking. Your best point is this: 1, 2, 3, 4, 5. Now, for example, if a judge is enamored of point number 4,
Right.
where you have a weak case, there's no point flogging 1, 2 beyond a point. You must have a plan B to put the question on point 4, which is against you prima facie, in the right way. So you have to flow with the tide. I'm talking of advocacy and litigation. I'm not talking of chamber lawyering. So flowing with the tide is a common mistake, that you are, judges talking on North Pole, you are talking continuously of South Pole. Judges going north, you are going east. So that you need to tune and sync. And then you try, on that syncing, you try to take a little different. The ability, to, as I said, to be able to tell the same thing in 3 different ways is the second point. Because the judge thinks he's made the point against you. You must be quick to absorb that point and approach the same result through a different pathway. You'll be surprised how many times the judge accepts a separate pathway with the same result.
You need to know the nerve of the judge.
Exactly, that's the right phrase.
Most of the time, like initially, it's always seen, whenever you get a new matter, you have to see before which judge it is coming. So you need to understand the psychology of that judge.
That's the negative part of what I said. I was saying the positive part, but the negative part is that today you have not one but at least 10 Supreme Courts in the Supreme Court. So judge subjectivity is something we have to live with. We have to flow with that tide. We have to know the nerve, but it's not a good thing. When I said you need to flow with the tide, I meant advocacy skills.
Right.
But today, equally, judges and judging has become far too subjective.
I cannot approach my matter objectively.
Yeah, so that degree of subjectivity is not good, but you have to live to learn with it.
That's true.
As I said, you can't have 10 Supreme Courts. As I joked once with Justice Pathak, Chief Justice Pathak, that if I was to make a hypothetical exam question into a paper book, SLP, and assume that you can draft something capable of 6 solutions. It's not easy, but assume that, like a mock question. So a mock SLP. And in confidence, circulated to 6 different benches. I told him we would come up with at least 5 different results, if not 6.
That's true.
Now that's pretty bad for the system, because that means there is no consistency of approach.
But don't you think that's what AI would bring in? The objectivity? No?
No. Ultimately, it has to be a human element. AI will give you templates, and AI will give you options, and AI will answer as a slave what you as a master ask. But these are not, at the end of the day, for solution, for reform. AI should not be allowed to cross that red boundary flag.
So these are all the court skills once you are in the court. But I think the job of lawyers starts the moment they get the brief or they are in the client meeting. How do you go about it?
Well, luckily I don't have to do much of this because, as they say, paka pakaya aata hai hamare paas.
Initially, yes.
But basically, I think drafting is very, very much more important than the importance it is given. I'll give you a simple example for Supreme Court practitioners. Today, the most important case, the poor judge, think of the poor judge also. The fellow is sitting with 55 to 60 cases, or at least 50 cases. Many may have read earlier, but there will be new ones. He has only 2 things before him, which he can apply his mind to. One is a judgment, which obviously is against you because you are the petitioner.
Right.
What else does he have to see your point of view? You have a briefing advocate, you have the client. Does he have that? No. He has his clerk.
Right.
The clerks are not necessarily always accurate or good. So the first important thing, I'm talking of Supreme Court or even in High Court, the primary matters where you are petitioner, you are underestimating the power of the synopsis. If you are lucky, the judge will read your synopsis. That's the only thing you will read apart from the inferior order. Do you know that how many lawyers fail in not making a synopsis like a written submission? They make a synopsis like a khana purti, like a काम करना है. But उस synopsis के आधार पर निर्णय देने का निर्णायक एक स्थिति आती है जिसमें कि जीतने और हारने का फर्क पड़ता है. क्योंकि जब जज पढ़ता है वो हाई कोर्ट का ऑर्डर या निचली अदालत का ऑर्डर, उसके बाद जो उसका विपरीत मत है वो सिर्फ आपकी सिनॉप्सिस से मिलता है. So tell me how many synopses are drafted as written submissions. See, a synopsis like a pleading is useless.
Yeah, really.
Because you might have to read the whole file, for which he doesn't have time. You must draft it like a pleading with pointed things. So I now, when files come to me for settling, I never settle anything except the synopsis. I said, if you got it right in the synopsis and it can't exceed 4 pages, maximum 5 pages. Everything. And if the judge is not moved by your first 5 points, then your 6th, 7th and 8th point, buried deep under in the SLP, is not going to make a difference. So you must be able to point out why the impugned order is erroneous in the synopsis, made like a written submission, not like a pleading, and concisely put in 4 pages out. Most people start doing it after they reach me and after they file. That's wrong.
No, what they do is they'll draft the main pleading, and after that they'll go and just.
And like a
one
pleading, not
synopsis.
like a written submission.
Yeah, that's true. That's a very fair point, actually. You're a politician and a lawyer, both. Has there been a time where you were like, because of your political duties, you could not take up a
Hundreds of
case?
times. I used to keep a list. I have suffered huge professional and monetary prejudice. My own doing. I'm not complaining against anybody. Because not only have I been conflicted, that's all right, that you do all the time. But this list is of hundreds of cases where the perception of conflict I have not taken. And I disagree with it totally, but I do it. Let me give you an example. The perception of conflict means that, technically if I am a member of the Congress, there is no reason why in a murder dispute between you and somebody, where you are a BJP councillor, I can't pay for you. Why can't I? When your tooth aches, you don't go and check whether the dentist is a BJP dentist or a Congress dentist.
Right.
But that is not the politics of perception in the country today. Both your own party and other party people will go and carry tails for no reason. Then there are a whole category of cases where the perception is that the Congress stand is against that.
But
why you
as
should...
a lawyer.
Exactly. That's the way it should be. So I have practiced it to a large extent that mostly I ignore that perception. But there are some cases where perception is so overpowering in the press that I cannot, even though I can as a lawyer. A child rapist I can represent without believing in him, without agreeing with him. But maybe I cannot as a 20-year member of Parliament. I don't know. This is therefore my biggest grouse against the media and against society is that the biggest censorship is not that by external sources, not by the government of India. The biggest censorship is your own compulsion to conform.
It's true.
Your compulsion to conform comes from an external standard set for you by an external so-called media who says that you should act and behave the way the media or the society assumes you should act and behave.
Or how they are going to project you to the society.
That's a compulsion to conform. Yeah. But unfortunately, we are all victims of compulsion. You cannot get out of it. Judges can't get out of it. Judges have to decide on the compulsion to conform. That's another big problem of the sub judice rule. The sub judice rule has almost died now. But a part of the sub judice rule is overridden by the compulsion to conform. अरे अगर मैंने ये निर्णय दे दिया तो समाज क्या सोचेगा? What will they think of me? That's the compulsion to conform. If I say this, what will they think? I may be speaking the truth. The harsh truth is this is green.
Right.
But if I say it, what will society think of me? That is the compulsion to conform.
So, are you a lawyer first or a politician?
Oh, clearly a lawyer first.
You're a lawyer first? Okay.
My strength in politics is that I'm an insider-outsider. I'm not an insider-insider. Of course, I'm not outsider-outsider. But I keep a little distance from it and that increases objectivity. Also being in law increases my strength in politics because your strength to walk away, your strength not to be dependent exclusively on politics is a big strength. People make fun, people are jealous, people decry. But ultimately, the fact that I am not entirely dependent on this gives me a strength which every politician may not have.
If somebody would make a movie on your journey so far, what do you think would be the title?
That's a difficult one. First of all, I have no illusions about myself. Secondly, I don't think I deserve a movie. now you're asking the third one that you're saying, assume all these things and then answer it. Titles are,
You must
ephemeral.
have a theme in your mind that this is how my life has unfolded.
Well, the books have been written with chapters on me. And one of the chapters is titled The Ultimate Multitasker. There is one
That's
actual
where,
thing. The other is, I think multitasker does sum up diversity.
You are into music. Any song, lyrics which you think, oh, fit well on my life, you relate to?
I am very clear about what my core competence is. Music is purely a hobby, and I enjoy it. I think I have a genre, a collection of patriotic songs, philosophical songs, romantic songs. So fitting into your life is not the right test, I think, but I love various categories of these songs. A very morose, sad song may be Mera Jeevan Kora Kagaz, Kora Hi Reh Gaya. A very nice romantic song will be Pal Pal Dil Ke Paas Tum Rehti Ho. One of my favorites, both philosophically and life-wise, probably the number one, is Kasme Waade Pyar Wafa Sab Baatein Hain Baaton Ka Kya. A patriotic one is Hey Mere Pyare Watan. But you can't say that any one lyric fits your life. That's oversimplifying it.
That was really wonderful talking to you. And I think the whole conversation, the more I've been 7 years into practice, and what I've learned from this conversation, it has changed my perspective towards litigation. How I approach the matter, how I approach my briefs, what do I have to do now onwards when I look at my brief, and that this was very enlightening.
Very kind of you to say
Thank
that.
you for having
Thank
a
you.
conversation
Thank
with
you
us.
so much.
Thank you.
Thank you so much.
Those were the insights every litigating lawyer should have in its toolkit. Straight from Dr. Abhishek Manu Singhvi. For more such conversations which goes beyond the law books, stay tuned and please like, share and subscribe to SCC Online.